Good day, everyone. I'm Thelma Suayan.
I'm Mary Jane Carabuena.
Jose Villanueva.
Darby Miranda.
Is Genevieve Enriquez.
We are the group 6.
Defective contracts, unenforceable and void contracts. Unenforceable contracts cannot be enforced through court action unless first ratified. Unenforceable contracts are valid contracts. Ang isang kontrata ay maaaring hindi maipapatupad kapag ang ilang mga kinakailangan ayon sa batas ay hindi pa natutugunan. Halimbawa, ang isang oral na kontrata para bumili ng lupa ay hindi maipapatupad dahil ang statute of frauds ay nangangailangan ng naturang kasunduan na nakasulat. Contracts which are unenforceable unless ratified. First, an agreement that by its terms is not be performed within a year from the making thereof. Second, a special promise to answer for the debt, default or miscarriage of another. Third, an agreement made in consideration of marriage other than the mutual promise to marry. And an agreement for the sale of goods, chattels, or things actions at a price not less than 500 pesos. And lastly, an agreement for the sale, for the leasing for a longer period than a year. Three kinds of unenforceable contracts. First, unauthorized contracts. Second, those that fail to comply with the statute of frauds. Third, those where both parties are incapable of giving consent to a contract.
Unauthorized contracts, those entered in the name of another person by the one who has been given authority or legal representation or who has acted beyond his power. Example, without Manolito's authority, Maninita sold the latter car to Manolito. A contract may be deemed void should the terms require one or both the parties to participate in an illegal act, or if a party becomes incapable to meeting the terms as set forth, such as in the event of one party's death. Unauthorized contracts governed by Article 1317. Article 1317. No one may contract in the name of another without being authorized by the latter or unless he has by law a right to represent him. Any promises made in connection the marriage, including such gifts as an engagement ring, contracts that cannot be complete in less than 1 year contracts. For the sale of land, promises to pay an estate's debt from the personal funds of the executor. Example, Pedro and Gina. Pedro did not authorize Gina to sell the hacienda, but upon being informed that she had done so, instead of demanding the annulment of the sale, Pedro proceeded to collect the installment, the amount of the promissory note given for the purchase of the sale, and necessarily implies his favor of the right to avoid the contract. Those that fail to comply with the statute of frauds, enhanced not only to prevent fraud but also to guard against the mistakes of honest men by the requiring that certain agreements that are the susceptible to fraud must be in writing, otherwise they are the unreservable action in court. Its chief characteristics is the provision that no suit or action shall be maintained on certain classes of contract engagement unless there is a note of memorandum in writing signed by the party to be charged of authorized agent.
Requisite for a person to contract in the name of another. He must be duly authorized expressly or impliedly. Or, ibig sabihin dapat siya ay nararapat at autorisado. He must have a by law right to represent him, like the guardian or the administrator. Ibig sabihin dapat siya ay mayroon karapatang kumatawan ayon sa batas tulad ng tagapag-alaga at tagapagpangasiwa. The contract must be held subsequently ratified, expressly or impliedly by word of dead. Ibig sabihin dapat ang kontrata ay pinagtitibay sa pamamagitan ng salita o gawa at may malinaw na oral. Article 1405, Contracts infringing the Statute of Frauds, referred to in number 2 of Article 1403, are ratified by the failure to object to presentation of oral evidence to prove that same or by the acceptance of benefit under them. Ibig sabihin sa pamamagitan ng kabiguan na tumutol sa paglalahad ng oral na ebidensya upang patunayan ang pareho sa pamamagitan ng pagtanggap ng benepisyo sa ilalim nito. Two ways of ratification of contracts infringing the statute. May dalawang paraan sa pagpapatibay ng kontratang lumabag sa batas. Failure to object to the presentation of oral evidence. Kabigo ang tumutol sa paglalahad ng oral na ebidensya. Acceptance of benefit under them, since the statute does not apply to contracts which are partially executed. Pagtanggap ng benepisyo sa ilalim ng mga ito dahil sa batas na hindi malalapat sa mga kontrata bahagyang ibinubukod.
Void contracts. When we say void is essential elements are present and it is expressly declared by law to be void. Void contracts. These contracts cannot be ratified, neither can the right to set up the defense of illegality be waived. Article 1409. The following contracts are inexistent and void from the beginning. A. Those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy, or LMGPP. B. Those which are absolutely simulated or fictitious. C. Those whose cause or object did not exist at the time of the transaction or the object could not come into existence because the object may legally be a future thing. D. Those whose object is outside the commerce of men. E. Those which contemplate an impossible service. F. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained. G. Those expressly prohibited or declared void by law. Characteristics of void contracts. First, right to set up the defense of illegality cannot be waived applicable even if not raised in trial court. Second, action or defense for declaration as insistent does not prescribe. Third, not able to third person whose interests are not directly affected. Fourth, cannot give rise to a contract. Fifth, produce no effect. Sixth, no action to declare them void is needed. And last, cannot be ratified.
Article 1411. When the nullity proceeds from the illegality of the cause or object of the contract, and the act constitute a criminal offense, both parties being in pari delicto, they shall have no action against each other, and both shall be prosecuted. Moreover, the provisions of the penal code relative to the disposal of effects or instrument of a crime shall be applicable to the things or the price of the contract. It simply means that Article 1411, it refers to a contract that is void because it proceeds from the illegality of the cause or object, and the act constitutes a criminal offense, either both parties are in pari delicto or only one of the parties is guilty. It speaks of an act which has an illegal cause and the act constitutes a criminal offense. Ang pataharang ito ay dapat iangkop sa partido na nagkasala, ngunit ang kainosentehang isa ay maaaring kuhanin ang lahat ng kanyang binigay. Article 1412. If the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. Article 1412 is also a void contract, but the unlawful or forbidden cause does not constitute a criminal offense, but nevertheless it is unlawful or forbidden. When the fault is on the part of both contracting parties, again, neither may recover what he has given by virtue of the contract or demand the performance of the other's undertaking. When only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract, or ask for the fulfillment of what has been promised by him. The other, who is not at fault, may demand the return of what he has given without any obligation to comply with his promise. So, para po mas maintindihan natin, I make a summary about unenforceable contract and void contracts. Unenforceable contract, defect caused by a lack of form, authority, or capacity of both parties, not cured by prescription. When we say void contracts, if defects is caused by lack of essential elements or illegality. Unenforceable contracts. It cannot be enforced by a proper action in court, while void contracts do not, as a general rule, produce legal effect. Unenforceable contracts, actions for recovery may prescribe, while in void contracts, actions for declarations of nullity does not prescribe. Both unenforceable contracts and void contracts cannot be cured by prescription. Unenforceable contracts can be ratified, while void contracts cannot be ratified.